introduce yourselves, tell us who you are, and when Amanda comes, we'll take a break and have her introduce. Go ahead.
My name is Carolyn Horde.
Make sure your microphone is on, please. Push the green light.
Okay, thank you. Senator Mensch and Senator Washington, members of the committee, thank you for the opportunity to speak to you today in support of House Bill 162. I would like to make one comment before I start with the text, and that is that I did get information from the Department of Public Health about 2 weeks ago, Department of Public Welfare, excuse me, and in the 3 years that the information registry has been in existence, they have only made 10 matches. So I think that gives you an indication of how ineffective it is. I think one thing, it's hard for people to even find it because in order to get to the registry, they have to go to adoptpakids.org. And that, to me, is not a logical place for an adult seeking information about the registry. So that information is as of 2 weeks ago.
Can I ask you to please introduce yourself?
All right. My name is Carolyn Horde. I was born in Delaware County and now reside in Chester County. I've been a member of the American Adoption Congress since 1998, a past president of the organization, and currently a member of its legislation committee. I am the mother of 5 sons and daughters, excuse me, only one of whom does not have his original birth certificate because I am a mother who placed my son for adoption in 1964. Despite the fact that I shamed my family by having a child out of wedlock, moved 1,000 miles away so neighbors wouldn't learn about my pregnancy, and gave away my own child, I have my original birth certificate from Harrisburg. My son, who did not choose to be born or choose to be given away, who did nothing wrong other than be born to an unwed mother, is treated differently than his siblings. Of my 5 children, he is the only one who does not have a copy of his original birth certificate, simply because he is adopted. My son was born in Florida, another sealed record state, but had he been born in Pennsylvania, the result would have been the same. He would have been denied access to his own birth certificate. Despite his request to Catholic Social Services, the Division of Vital Records, and the court in Palm Beach County, Florida, my son passed away at the age of 37 without ever having received his birth certificate. Pennsylvania-born adoptees pass away day in and day out without ever seeing their original birth certificate. Opponents of this bill will tell you that birth parents were promised confidentiality when they signed the relinquishment papers. This is not true. There is nothing in the relinquishment papers signed by mothers that promised us confidentiality from our own sons and daughters. Title 23, Chapter 27, Section 2711D of the Pennsylvania Code requires that the consent signed by a parent of a child to be adopted contains this statement: I understand that by signing this consent, I indicate my intent to permanently give up all rights to this child. Nowhere does the consent guarantee the relinquishing parent confidentiality from her son or daughter. By giving up all rights, one can assume that those rights include giving up any right to privacy or confidentiality she may have thought she had. Elizabeth Samuels, a professor of law at the University of Baltimore School of Law, wrote a paper entitled Surrender and Subordination, Birth Mothers and Adoption Law Reform. Attorney Samuels reviewed over 75 surrender documents provided to her by birth mothers for the period 1939 to 1990. Not one document contained a written promise of confidentiality. Quoting from the article, the birth mother advocates stressed the fact that birth mothers were neither offered a choice of being nor guaranteed that they would be forever unknown to their children. That fact, emphasized in birth mother accounts and corroborated by the surrender documents, makes it fair to ask, why is something I was supposedly promised, which I did not want and never heard of, so important now that it is used to deny adopted adults their civil rights? I challenge anyone here today who opposes this bill to produce one document wherein a birth mother was legally promised confidentiality in writing. If a mother relinquishes her child, but that child is never adopted, the birth certificate is never sealed. How does that protect the mother's privacy? Additionally, court decisions in Tennessee and Oregon have confirmed that there was never an absolute guarantee of birth parent confidentiality in any adoption. Until 1984, adult adoptees born in Pennsylvania were treated fairly and exactly the same as every other Pennsylvania-born person. However, in 1984, a Pennsylvania legislator convinced the General Assembly that pregnant women would opt to have an abortion if they thought their son or daughter could search for them 21 years later. His argument has proven to be untrue in the states that have allowed access. In 2011, the Guttmacher Institute of New York issued its report on adoption data. 6 states passed access legislation between 1999 and 2009. In 5 of those states, abortions have decreased since passage of access laws. In Alaska and Kansas, where records have always been available, abortion rates are well below the national average. The laws passed in Illinois and Rhode Island are too recent for data to be available. There is no evidence to the opponent's claim that allowing adopted adults to obtain their original birth certificate will lead to increased abortions. Since Delaware and Tennessee changed their law in 1999, up to May 2010, when Illinois did so, over 30,000 adult adoptees have received their original birth certificate. We are not aware of any negative impact this has had on the lives of birth family members. On February 26, 2014, Carla Crane, Post-Adoption Services Program Manager in Oregon, wrote, "The result of passing adoption reform in Oregon has not been a realization of the fears expressed by few, but rather a greater understanding of the benefits of and support for the access to adoption information." Some people misunderstand the intent of this bill and believe that it opens the door to adoptees and others obtaining every document relating to their adoption. This is not the case. House Bill 162 is about an adoptee having the right to one piece of paper only, the original birth certificate. The adopted person's need to receive his or her original birth certificate does not reflect negatively on their adoptive family. It is simply a desire to know who they were at birth, what nationality they really are, what name they received at birth. It is a basic human need and one which the Commonwealth of Pennsylvania has denied them since 1985. The original birth certificate is considered a legal document, a factual snapshot of the beginning of the person's history. It belongs to the adopted person. As a birth parent who placed a son for adoption, I support House Bill 162, and I urge you to do the same. It's time to give Representative Benninghoff, Representative Kathy Watson, and all adopted persons the same civil right each of you enjoys, the right to know who they are. Thank you.